I will be presenting the workability claims and disadvantage claims of the affirmative side. The affirmative side claims that there needs to be reform within the three strikes law because too many criminals are given 25 years to life sentences for nonviolent felonies. The law costs too much money to house criminals, and the law encourages criminals to participate in more crime. Though a formal plan for a reform is given by the affirmative, any such reform would prove to be unbeneficial. The claim made that it is wrong to imprison someone for at least 25 years for a nonviolent crime is made solely on the degree of the one crime without taking into account the criminal record of the person. According to the California Legislative Analysis Office, second and third strikers have been convicted for an average of 3 prior felony offenses, including an average of 2 prior serious or violent felonies. This means that the chances of a criminal who is being convicted for a nonviolent crime of having a violent past is greater. Also, according to the Bureau of Justice Statistics, 56% of the violent felons convicted in the 75 most populous counties from 1990 through 2002 had a prior conviction. The Bureau also reported that 38% had a prior felony conviction and 15% had been previously convicted for a violent felony. The affirmative claims that sets out to make criminals the victims and the audience sympathetic towards them, when the facts show that many of these criminals have a past of violence. The second claim made by the affirmative is that there is a high cost of keeping this type of legislation. With any government program or law comes a price. The increasing population of inmates is said to be the result of such legislation as the Three Strikes Law. But according to threestrikes.org, a study done in 2006 showed that California's Three Strikes Law sentencing has not overflowed the state's prisons, and in fact there's a slight 0.7% increase. And the site continues to say that although California's population has gone up by 14 million residents since the passage of the Three Strikes Law in 1994, that crime has not gone up proportionately. And an increase in inmate population is to be expected with the growth of any population and cannot be blamed solely on the Three Strikes Law. And regardless of the law, we have to deal with the growing prison population. And a reduction in the cost through reform of the Three Strikes Law would only result by limiting the number of criminals that are being convicted and to release criminals that were sentenced on a non-violent crime. With the removal of non-violent felonies from the list of strike offenses, more criminals would be on the streets. This reform would encourage past felons to direct their crimes towards those not under the Three Strikes Law. The releasing of felons who were convicted on non-violent felonies would also pose problems. According to a Washington Crime News Survey study, of the offenders with prior felony records, the study found that at the time of the new crime, 18% were on probation, 12% on release pending disposition of a prior case, and 7% on parole. So this statistic means that 37% of felons who were released on some type of court order committed another felony. And these studies prove that most of the felons under the Three Strikes Law will continue to commit felonies regardless of the law. And the third claim, that criminals would in fact want to commit more serious crimes because of our harsher penalties, seems to be an unsound claim. Because the affirmative earlier stated that there was indeed a decrease in the crime rate, but suggests that because of this law, that more crime would go on. And regardless of whether or not the passage of this law affects the crime rate, the affirmative contradicts their claim by acknowledging that crime did decrease, but claims that the law would increase crime. And so this contradiction makes the affirmative claim seem invalid. In addition to these claims, the question of whether or not the Three Strikes Law is ethical and constitutional often comes up on this topic, as the affirmative earlier stated. And the topic of whether it is a violation of the 8th Amendment of cruel and unusual punishment has made its way up to the Supreme Court. And the court ruling involved a third-strike felon who was looking at a sentence of 50 years to life and protested that the sentence was a form of cruel and cruel and unusual punishment. According to the California's Legislative Analysis Office, in 2003, the U.S. Supreme Court, in a 5-4 decision, upheld the constitutionality of California's 3 strikes law. The court justified the ruling by stating, the sentence is justified by the state's public safety interest in incapacitating and deterring recidivist felons, and that selecting sentencing rationales is generally a policy choice to be made by state legislators, not federal courts. And so the Supreme Court makes the 3 strikes law constitutional and perfectly legal in the court of law. And so in addition, the Supreme Court also gave judges the right to dismiss prior felonies. According to the California Legislative Analysis Office, in People versus the Superior Court, the state Supreme Court ruled that the 3 strikes did not eliminate judicial discretion to dismiss prior serious or violent convictions. What this means is that judges in court do have the right to dismiss prior minor felonies for criminals to avoid the 3 strikes penalty in some cases. And with this power, judges are able to drop a strike for felons in these types of cases. And surveys of district attorneys conducted by Jennifer Walsh of California State University of Los Angeles suggest that prior strikes might be dismissed in 25% to 45% of 3rd strike cases, resulting in shorter sentences for those offenders. So overall, the 3 strikes law that is in place right now is in the best interest of the state of California, since it keeps felons off the streets, which in the end prevents repeat offenders from committing more crimes. And how many chances are we going to give criminals before they stop committing crime?